Hello, everyone, and welcome to today's webinar. My name is Jonathan Brandt, and I'm with Peak Trust Company. I am very excited to welcome you to the third installment in our four-part series on private retirement trusts. If you've been with us for the earlier sessions, thank you for joining us again. And if you're just tuning in for the first time, we are glad to have you here. We have a quick few housekeeping items before we begin. If you have questions, you can submit them at any time using the Q&A panel. We'll answer them live throughout the session, and if we don't get to your question, we will be sure to follow up afterwards. Additionally, the slides for today's presentation will be available for download in the event dashboard, and we'll also send them to everyone who is registered after the session has concluded. At Peak Trust Company, we specialize in trust administration for high net worth clients and their advisors. We serve clients across the US and internationally, and we're proud to operate in the top tier jurisdictions of Alaska and Nevada. Our mission is to offer flexible trust services and empower planning professionals with the tools they need to execute complex estate and asset protection strategies. In today's session, we're diving into the logistics and planning of implementing a private retirement trust. We're going to be building on the concepts covered in part 2, particularly the importance of establishing a credible retirement purpose. This session is all about putting the plan into place. To guide us through this material, I am pleased to once again introduce our speaker, Dustin Nichols, founding attorney of the law office of Dustin Nichols. Dustin is a recognized leader in exemption planning and one of the original architects of the California PRT methodology. And with that, it is my pleasure to turn it over to you, Dustin.
Thank you, Jonathan, for that fantastic introduction. I certainly appreciate the opportunity to speak here today to your great viewers, share some of my knowledge and understanding of this very unique tool known as the Private Retirement Trust. We're going to be discussing part 3 today, which is one of my favorites because that really sets the groundwork, the landscape, I should say, for the right kind of thinking around the planning and how we do these things. Because I do believe that the devil is in the details in this stuff, and you definitely want to make sure you're clearing a path for a client or for yourself if you're going to do any planning that results in moving something away or into a protected vehicle, but regardless of whatever you're doing in your planning. Even in exemption planning is relevant. So planning logistics, part 3, that's what we're going to be discussing today, and I highly recommend you take notes because I think, like I said, we've refined a very robust due diligence process that I believe certainly puts a client in a much better position to do planning than if they didn't. So in our planning logistics outline, if you will, that usually involves a phase 1 due diligence engagement. That's what I call due diligence. We're going to walk through our exemption assessment report, a solvency review, and affidavit. I think that's key. And if there's any issues surrounding a client at the time, any claims that may be pending, threatened, or expected, they do require attention. And I'll explain a little bit more in detail why as we move along. Phase 2, that's when we've cleared the path. In phase 1, we've identified the type of planning that we're going to be doing in terms of the integration with the PRT, any LLCs that need to either be created or retirement purposed, as I call it. That's all done in phase 1. Phase 2 is when we actually pull the trigger and create and implement the PRT. And in that, we're going to be discussing the engine behind the PRT, which is our retirement appraisal. This is how much we can stuff the box with and with what and why. The actual creation of the PRT documents, the adoption of the plan and the PRT itself, all of that covered in phase 2. And concurrently with the implementation and creation of the PRT, we have annual administration. It's key that at that time we have our trustee engaged. We have all of the administration, the asset tracker, as I call it, that we create that pinpoints every asset that's gone into the structure and anything that needs to be done in correspondence with that. It could be making an annual contribution that's been scheduled on time. Administration will let the client know 60 days and 30 days that they have that payment due. It's real important to respect the rules and obligations created in the plan. And if we don't do that, if we don't respect the stuff, then certainly a court is not going to respect it. So that's the overview today. I think it's very valuable information, and I hope you guys like it. So in our phase 1 due diligence, like I said, we go through a full exemption assessment report. That's gathering up all of the client's asset information, their liabilities, We get values, hopefully supportable, right? Even broker price opinions are helpful for real estate, things like that. But we want to know ultimately what's currently exempt and not exempt on the client's balance sheet. That gives us an idea of where their current exemption status is, what percentage of their total net worth is exempt under statutes, under federal or state exemption laws. That's key, because again, at the end of the day, that's your biggest strength in any potential workout, especially if there's potential bankruptcy on the horizon, which hopefully never has to get pulled as far as the trigger goes with that. Now, solvency, again, you cannot walk into these transactions insolvent. That's the one thing I've learned, and you'll see in cases over and over again. That's one of the biggest badges of, I used to call them badges of fraud under the Uniform Avoidable Transactions Act, is if a client walks into this insolvent, it's very clear that the intent wasn't necessarily just to do some retirement planning. If you're insolvent going into this and there's trouble on the horizon, then ultimately what you've done is commit avoidable transfer. So it's real key that we vet the client's solvency in this process. And then, of course, the corresponding very robust affidavit that accompanies this, I think, is huge as well. At the end of the day, what we're trying to do is show the client's doing this planning for all the right reasons, not for any other improper reason. If you've watched my last series on planning with retirement purpose, this goes towards that, to show that ultimately here, the primary purpose for this planning is retirement and not, well, avoiding a creditor. Right? Asset protection is a secondary acceptable purpose under the Schwartzman case. We don't abuse that. And if you remember in planning with retirement purpose, the 5 factors that the court looks at under the O'Brien case to determine the validity of a PRT, I highly recommend you go back and review those, because this kind of all leads together and we want to make sure we're checking the boxes here for the client. So if there is litigation or a possibility of litigation going on, we do a thorough analysis of the claim and vet it and look at any defenses, any cross claims. We can interview the lawyers. All of these things help to show that, again, the intent behind this is in the right place, that we're not doing anything here to intentionally delay, defraud, hinder the rightful entitlement of a creditor, which is the most often used test by a creditor under the Uniform Avoidable Transactions Act to set aside transfers, anything. To gather this information, in order for us to acquire the necessary data to do our evaluation, we send out a PRT asset questionnaire. It's a pretty thorough questionnaire. Gets into all of the different assets that they may have, the current owners, any loans against them. Again, this is all part of what we need to be able to come up with that exemption assessment report. Now, we built a calculator, and this calculator, after we've spreadsheeted, if you will, all of the asset information and liabilities by their respective exemption categories under the statutes. Every statute has a category, right, that this particular asset may apply to. You got the homestead exemption for your principal residence. There's the life insurance cash value exemption, 15,000 and change, doubled for spouses. All of those are part of what make up the algorithms behind the calculator, within the calculator, that can analyze a client's current balance sheet to determine what's exactly exempt and not exempt, for purposes of knowing what's protected and what's not protected currently, and what we might be able to do with the PRT in the future. I'll walk you through these, but let's just take an example. We have Tom. This is the calculator in practice. He's 20 million in net worth. He's 57 years old with a projected retirement age of 65. By the way, 65 is not a magic number. It's just something we use because it's traditionally used in retirement planning, but under ERISA. But we don't have a restriction on age, so just be aware of that. Married, he's got no kids. He's a business owner, lives in Orange County. That's relevant for the homestead exemption, because the homestead exemption in California is county specific. It's all 58 counties that have to be evaluated, and it depends on the statute, which is a minimum of 300,000 protection, maximum of 600,000, depending on the median sale price of a single family home the year before, adjusted for inflation. Just take all that in. But anyway, this is all in the calculator, but that's something relevant, the county. And then annual income is 900,000 a year, $7.1 million worth of commercial real estate, 3.3 million in principal residence, quote, net equity. Okay, this means his net equity. What does that mean? It means it's any amount, obviously, over any loans and the homestead exemption, which in Orange County right now is about $722,155 and change. Again, will be adjusted next year, but that's relevant to the conversation. 3.3 million of principal residence net equity, 2.5 million in a single shareholder S Corp stock value, just an investment stock portfolio of 2.3 million. It's about 2.3 million in cash, a million in ERISA qualified pension plan. Again, trigger ERISA. That's a federal exemption. So we know that million should show up under the calculator as exempt under the ERISA laws. And then 700,000 of life insurance. We're not going to, that's cash value, not death benefit or term. That's cash value in the policy that's exposed beyond the 15,000 and change. There's 500,000 in personal property, very small personal property exemptions, 5,000 and change for those. So not a lot you're going to find there. And the IRA is a rollover. See where it says rollover? And this is interesting because rollover IRAs are treated differently than just straight traditional IRAs under California state law. Why? Because rollovers were originally in a part of a ERISA plan, usually a 401k that rolled over into an IRA. That rollover retains its exemption protection status under the Haycock case, which is a Ninth Circuit case. So just so you know, as we're looking through these, got to know the case law relevant to where the exemption protections lie and where they can be maintained. And for purposes of our discussions here, it's real important to take away that rollover IRAs retain their exemption protection under ERISA. Now, after plugging all this data into our calculator, this is what we get by way of a result. So page 1 of our assessment report is what I call our, creditor exposure report. So Tom, he's about 78% exposed. That means the lion's share of what he owns is not exempt. He's got some protections at 12%. These are corporate protections. Could be charging order protection. It could be buy-sell agreements and things that make it some difficult. But we're not talking exemption protections. We're just talking other protections that may be useful, but certainly are nowhere as potent as the exemptions. And then 10%, that's the stuff no one can touch. That's the stuff that's exempt, either under federal or state law. So Tom, if his world went to HE double hockey sticks in a handbasket, at least we know that 10%, $1.9 million, is what he gets to keep out of his 20 million. Not exactly what we would call the best result, but I've seen worse. And page 2 of the exemption assessment report is what I call our exemption protection potential report. What does that mean? By integrating some of our traditional retirement modeling, the 3% inflation rate, we look at the client's total balance sheet, in other words, net worth, what their income is as of that particular year. Those are key factors, right? All of those things and the horizon to retirement all put together equal what we might be able to recharacterize as exempt on their current non-exempt balance sheet as retirement assets that are exempt. In other words, those particular assets the client can't lose, that they're going to look to and towards to sustain and maintain their lifestyle through retirement. All right, those are the things, but we're not getting real specific at this stage. We're not getting real particular of which assets might do that, but we're just kind of looking at everything in a bulk at a 30,000 foot saying, all right, then we have a potential here to improve the exemption protection potential substantially by using the PRT, right? That's what page 2 does. And that's usually where the conversation with the client starts with, where do we go from here? How do we implement and create this tool, this vehicle that's going to put me in this better position? Now, solvency, that's another part of this. Like I said before, the client must be solvent when the PRT is funded, or the whole thing will get unwound and pretty quickly, because the law requires us in the Avoidable Transactions Act to be solvent when we walk into these. So we got to make sure when looking at all the, and what may be relevant to that as well as the personal guarantees the client may be signing. All of this stuff gets vetted and reviewed at the first due diligence stage. So we're not walking into this blind. We know ahead of time what we're working with, right? Whenever we do a PRT. Now, litigation or potential liability analysis, this is also, just like I was just saying, which is where we're looking at everything that might be a draw on the estate in terms of its value. And we do extensively review the personal liability resulting from judgments. Clients have any judgments. By the way, that's going to come out on our financial report. And one of the things that we do, and I think it's important to mention here, is that we flush out all known creditors. We do an independent financial report. We use a service used often by bankruptcy attorneys to identify all known creditors. We do the same thing, and we attach it to our solvency affidavit. In that search that's done by this service, we also flush out any judgments that may exist at the time. So we know about it, and while obviously there's a plan to work around it or through it, or we're probably not moving forward. We need to be able to show that whatever planning we're doing isn't to avoid one of these judgments. So we work around that. We try to figure out exactly where we're at. We talk to counsel. There's a counsel on this. Maybe they're in the process of settling. Any or all those things are relevant to flush out and review and even disclose if it appears like planning is still a possibility, given whatever that, it might be a small judgment. We have clients that have doctors that have 5 judgments against them at all times, or I should say lawsuits, not judgments. But obviously, if there are any of those, then we're dealing with them. We're looking at any pending, threatened, or expected claims, administrative proceedings, all of these things. We have to be able to flush out what's called basically a contingent liability. This is clearing a path to the retirement planning that we're doing. And I actually wrote an article on this, and if anybody's interested, certainly we can get a copy to you. And I will be posting, I think, back up on LinkedIn, the article relevant. It's my article 8, Clearing a Path to Retirement Planning. But I think it's a good idea to make sure that, again, we've identified and disclosed what these potential claims might look like in the form of contingent liability. In this case law that actually supports this analysis, it's the Zonix and Covey cases. Zonix is an 88 bankruptcy court case. Covey is an affirming case. They're persuasive authority, but they're very compelling in terms of how the court looks at determining a contingent liability amount to set aside so we can continue to plan. Also relevant for discussion and review, guarantee agreements, indemnity agreements. These are liabilities potentially. Spousal and child support orders. Yeah, one of the things the PRT does not protect against is spousal support, family support, or child support. Those are public policy exceptions, and they make sense. So our disclosure, or I call summary of due diligence findings and recommendations, is a letter we prepare that does a pretty decent job evaluating the claims, any issues that, like I said, pending, threatened, or expected. They all are disclosed here with our contingent liability analysis attached. And again, all for the purpose of showing the right thinking and proper intent when we supporting intent when we go into these type of transactions. Now, so after we've done everything at phase 1, like I said, including reviewing all of their trusts, and if there's trusts that are in place, we're going to look at QPERTs, and we're going to look to see whether or not the QPERTs have proper language that would allow for the maintenance of the homestead exemption. Believe it or not, under the Nolan case, which is a Ninth Circuit case, if you have proper language in your irrevocable trust that holds a principal residence, you have the right to live there, things like that, then you can retain the homestead exemption in an irrevocable trust. The homestead exemption is liberally construed under the law. I think I've mentioned that before in previous presentations, but it's important to note. But there still has to be some language in there that allows for that. So again, we're looking at trusts, we're looking at entities that hold maybe limited partnerships, we're looking at LLCs that owned income producing real estate, residential or commercial. We're reading those agreements to see if they need to be tweaked a little bit to allow for better integration with the PRT planning, non-voting and voting membership interest. Typically the PRT likes non-voting membership interest, doesn't want to participate in the actual business of the client. And there's also language in the documents in the operating agreement, say for instance in an LLC, that requires mandatory distributions at retirement. So all of these things help to, again, better retirement purpose, everything we're doing. And while we figure all that out in phase 1, and we kind of have an idea what that's going to cost, right? And before we move forward with a client, they'll know all of it and agree to all of it. And that's where we get to phase 2. Now we're talking about creating and implementing the PRT. So we've cleared our path in phase one. That can take sometimes some weeks to get through. It really just depends on the client and how quick and responsive they are. Not all clients are super responsive, even though they want to do this. It does require some effort, but we get through there with the minimum amount of hopefully aggravation and resistance, so we get to phase two. In phase two now, like I said, we're creating and implementing. And now where do we start? This is where I bring in my retirement appraiser. And what he does is he appraises the retirement need of the client. And there's the questionnaire. You saw that first part of the PRT asset questionnaire. We actually have a part two of that questionnaire. That goes out at phase two to the clients for them to fill out so we can get all the extra relevant data that we need. The retirement appraiser needs, like lifestyle expenses and all kinds of things, costs and what it costs to maintain and keep up all the properties and businesses and all of those things. Those are all relevant to the calculations. It's not just an actuarial calculation. It's deeper to determine the quote lifestyle and maintenance need of the client. So that's where this kicks off. We immediately turn over the work to the retirement appraiser to gather all that information. At that same time, we're over here creating the actual PRT adoption documents, is what we call them, right? That's where we're creating the private retirement plan itself. We're creating a trust for each of the participants, right? Again, we have a sponsoring company here that's adopting this plan. They're also the settlor of this trust for the benefit of the plan participant. And then we have an adoption agreement that adopts it all, and funding, right? What are we putting in the vehicle? If we're removing real estate, we may be moving fractional interests and exempting fractional interests of real estate into the PRT and then up into an LLC in exchange for, say, membership, non-voting membership interests with that right to mandatory distributions that I talked about. Right, all of those things, that's part of it. There might be a deed of trust that's filed on the client's principal residence that serves as the pledge, the funding, security for the client's PRT contribution promise. That's part of the funding, right? If you remember, what we fund with is two things: some lump sum amount, maybe cash, securities, property, but also there should be a gradual accumulation component in part three. When I talked about planning with retirement purpose, that's a big deal. We want to be able to have gradual accumulation of some amount of money into the plan over time under the Barnes case that shows that we are more retirement purposed in our creation. Part C, implementing the PRT, that's when we're actually getting everything together and everybody together in our final coordination and collaboration and executing all the documents. Who's going to be the trustee? Who's going to be the nestor, which is your investment advisor? Who's going to be your pilotes? Again, my Greek thing. This is a trust protector and the plan administrator. If we're not using a corporate trustee, we have private professional fiduciaries that we use an administration company to support company to keep the trustees' fees down and things like that, and aid in the maintenance and support for the client. So this coordination and collaboration, all of these things are absolute key to successful PRT. So the retirement appraisal, like I said, it does more than just do some numbers, calculate some numbers. It tells the retirement story. In the first page of our plan report, we literally tell the client's story. What's going into this thing and why is it needed? It establishes that need. That need is what supports whatever amount that was put into the PRT. So the need is absolutely key, and that's well documented. And it's real important that all stones are not unturned, so to speak, and the client participates in gathering and producing all the information to the retirement appraiser so that ultimately the resulting calculations can prove up the retirement need and the roadmap for the annual funding and everything else that goes into this. The creation of the PRT, at a minimum, we have to have, again, the proper and supportable retirement analytics. We go into a deep dive. I've seen them done, not specific in detail. I personally believe that it's an important ingredient to an overall successful PRT, because if it's the engine and it's what we're putting in this thing, then we need to be able to show and support and defend the amounts and the assets that we've put into these plans. And again, we've got to have a sponsoring company, employer. The client has to be an employee, participant, And for the retirement plan that's been created, retirement trust is the vehicle that holds and administers these retirement assets. If you recall, it's not what's exempt. It's not the trust. Remember, the exemption is personal. The exemption belongs to the resident, California resident debtor, and this has been a case where it's ever called into question, right? They're the ones that have the exemption, but the assets themselves are held and administered in this private retirement trust, which also has its own features. And I highly recommend viewing part 3 if you get a chance, because I go into detail on issues surrounding that. Independent custodian included, why it's important, because there's features in the trust that actually provide protections to anti-alienation provisions and things where an independent trustee is important to maintain the exclusion status of the PRT in a bankruptcy, say, for instance, which means it's not subject to the jurisdiction of the bankruptcy trustee. That's important. We want to make sure we're using all of our tools and maximizing all our protections at the same time. And then the annual administration and maintenance, absolutely critical. Now, the private retirement plan itself, there's well-established case law upholding the full exemption under CCP 704.115B for plans that are sponsored by wholly owned corporations that have a single shareholder director plan, trustee, and beneficiary. In 1991, in Ray Chang, the court addressed the issue of whether a corporate retirement plan in which one person controls the corporation and the plan qualifies for the private retirement plan exemption under CCP 704.115A1, or whether it must be treated as a, quote, self-employed retirement plan under subsection A3. That court held that a plan sponsored by a wholly owned corporation qualifies for the full exemption under CCP 704.115A1, and stated that although the legislative history indicates that the policy behind Section 704.115E, which is the IRA statute, is to limit the exemption for plans that are controlled by one person, the statute says what it says, and it was improper for the bankruptcy court to read beyond it. Quote, if the California legislature intended to treat closely held corporations differently than large corporations, it could have done so explicitly. That's straight out of the court's mouth. So my whole point is your employer sponsoring entity doesn't have to have a lot of people. It can have just one person. You can have one person business owner, single shareholder, single officer director, and it can create, or he can create, or she can create a PRT for themselves and have it treated and recognized and respected, which it also said in this case, like a big corporate plan that IBM or General Motors would implement. Now, we still have to establish certain policies and procedures. That makes sense. These have to have rules, and we need to respect our rules for these plans to be upheld ultimately. But the policies and procedures, they usually cover eligibility and participation in the plan, contributions, what are permitted and what are prohibited. I have some clients that want to contribute in digital assets and crypto, and that's fine. We allow for that. I have language in our trusts and adoption documents that provide for that, especially in our adoption agreement. Recharacterization of assets, it's clear that what assets are being funded into the PRT are assets that are recharacterized off of their exposed balance sheet as personal to, quote, exempt retirement assets. That's the recharacterization. It's clear in our documents that what we fund establishes this. It creates this result. The option regarding distributions, how does the client want to receive their retirement benefit when they reach retirement age? They can receive it in one lump sum. They can get it over time, which is what I recommend, because features that actually will help to continue to protect, let's say, the excess equity in the principal residence over the homestead exemption and any loans, that deed of trust, we don't want that to come off necessarily earlier than it needs to. And sometimes our PRT contribution promises are 20 years, 30 years out. We don't want to lose those protections on the house if we can help it. So most of my clients will opt to take the long-term distributions that will start at retirement date, usually are annual, but you can make them monthly, quarterly, so forth. Plan loans, we have policies and procedures surrounding loans, unsecured loans up to 50,000. Anything over that are usually secured. They should be at reasonable interest rates, commercially reasonable, things like that, because the court in its opinions does recognize that these, hey, if you're getting it from your PRT, you could have got it from a bank as well. So if you're paying your PRT and it's less than what a bank would charge, then it's question as to intent. Is it being really respected? Administrative matters, all of that is, again, set out in our plan to make it clear what the rules of the road are. Now, the trust itself, like I said, it's not the vehicle that's exempt, but it's the vehicle that holds and administers the quote exempt assets. It is a trust created for the benefit of the participant, which means if we have, well, more than one participant, then we're going to have more than one trust. We'll have one plan for the company, but we'll have however many trusts there are per participants. And this is non-ERISA, right? So there's no discrimination rules. And we've run this through our ERISA attorneys. It can be husband, wife. It can be even some top executives in the company that are non-family under the top hat exemptions. There's a trust for each of the participants. Exemption protection vehicle, it again holds those assets, administers those assets. When it's time to pay, it pays. It does have customized provisions in the document for the particular needs, if there are any that are special for beneficiaries, establishes policies and procedures with respect to the administration of the retirement assets including funding and distributions. And it does require a skillful and proficient PRT integrated team to make sure that it's being prepared properly, that there's the right amount of collaboration around it. That's why I like working with other law firms as special counsel to create these, because these folks are very intimate with their clients and know their needs and collaborate well in creating what I consider a really nice overall result at the end of the day. Like all trusts, you have a settlor, which again is the corporation. You have a trustee. We have a number of trustees, and you have a plan participant, which in this case is a beneficiary. Now, you're going to hear this and you're going to keep hearing it just because it needs to be a resounding message that it isn't just discarded. Retirement purpose is key in the PRT. What is considered principally or primarily designed and used for retirement purpose is critical to the survival of the PRT. It has to be principally or primarily designed for retirement purposes. And since the statute doesn't really get into it in much detail, you really have to look to case law and precedent. It gives us what we need. It gives us the breadcrumbs to follow. It tells us the do's and don'ts. And that gives us a really good idea of what works and what doesn't. At the end of the day, if you look at the case law, it's very clear that a lot of the cases that surround this particular statute are last-ditch efforts by folks and their bankruptcy attorneys to try and save money, and usually after something's already happened, right? But again, the court gives us, it goes over the top to give us the detail that we need to show us, hey, this would have been the right way to do it, as opposed to it's just wrong. That really helps us, like I said, gives us the breadcrumbs around this. And we have a 780-page compendium that we created that basically by topic heading hyperlinks all cases with highlighted dicta in all the cases to support all the things that we do and how we do it. That's the bullets I call in the gun. They're there and ready. And as long as we follow those rules and try to stay true to what we know we can do, then I believe we can have a really successful result. Now, the PRT, the Private Retirement Plan Trust Adoption Agreement, this is the adoption agreement. This is where the company sponsoring the plan adopts the plan. It says, okay, we're doing a PRT for certain plan participants. We're adopting the private retirement plan for the company that sets out all that stuff we talked about before, the policies and procedures. It will designate the participants that can participate in the PRT within the company. And it sets forth the terms for the plan, such as retirement age, vesting options, permitted contributions. Again, what we can contribute in that's acceptable. We establish that right up front. And Part C, implementation of the PRT. Now that we've discussed the basic documentation required to create a PRT, let's talk about the implementation of the retirement plan by the PRT integrated team, because it has to be properly structured. It has to be properly funded. It needs to be properly administered. And like I said, it requires, just like in any good planning, coordination and collaboration. And just something that always yields a much better result. Now, the participant, the client, there are certain things we need to understand about the participant. It has to be an employee of the sponsoring company. The participant receives the retirement benefits pursuant to the terms of the PRT plan. And the PRT is, like I said, customized for the particular needs of each participant. And as far as the death benefit, if you recall, the death benefit under the statute is also protected or exempt. So within the PRT, we have to have a beneficiary designation executed by the participant that says what happens to their assets when they die and where it goes. Now, this is a nice opportunity to integrate with other estate planning, at least in California. There's a trust that is revocable that becomes irrevocable at the death, let's say, of the participant or the settler, in the case of just a revocable living trust. The assets inside that trust, even though the trust is now irrevocable, are still subject to the claims of that person's estate. Now, because the PRT's death benefit is exempt, you can still use it directly in terms of if there's no spouse, say, for instance, because usually spouses get first crack, they're primary. And then contingents are the trusts, their living trust. The PRT will go to the living trust exempt from creditors of the estate and then pass pursuant to the terms. Now, a stronger, even more reinforced method might be, because under California law, if you set up an irrevocable trust ahead of time and then you die, and let's just say that's a children's trust, maybe there's, I call them pre-inheritance trusts, was a trust for each kid with the right for them to participate in the investments of the trust, like a non-managing position, non-fiduciary position in the trust, give them the chance to get their hands dirty. The kids are, let's just say those are in place, and maybe there's a slat or slant for a spouse. It could be carved up, the estate of the PRT designation, to put something in each one of those. But because the trust is, these are irrevocable trusts, again, not subject to the claims of the estate either. So now you've got the exemption and you've got a statute that says this trust is not subject to the claims of the decedent's estate, and you have even a stronger result. Something for thought. Now, the PRT retirement planner, that's our appraiser. He designs the retirement plan and the corresponding retirement appraisal, what we can put in it, so forth, establishes the matrix and amounts. What are the assets exactly that are funding, whether it's the lump sum stuff or the PRT contribution promise, any one or all of those things make up a matrix and amounts that is usually set up and part of the plan report. And the PRT planner can also serve as the nestor, depending on whatever the client's need is, but they have a real good, I should say, fundamental understanding of the benchmarks that need to be realized and so forth in these plans. But any good investment advisor, I'm sure, would understand the plan and be able to implement the plan right alongside the client. That's somebody, that's their trusted person, and certainly can be done. Our PRT trustee, very important role. Again, independent trustee is preferable. Remember, the trustee is the legal title holder of all the assets held by the PRT and is bound by fiduciary duties to manage those assets and carry out the purposes of the trust. If there's a nestor, that PRT trustee doesn't get involved in investments, the nestor or the investment advisor directs the trustee with respect to any investments. But again, independent trustee is preferable because of the anti-alienation provisions in the trust, and control would destroy those and destroy the exclusion status of the PRT in bankruptcy, which is something obviously we want to preserve. So independent trustee is important. Legal title holder, like I said, they're the ones on title and everything. They're the ones who hold it for the benefit of the equitable title holder. Who's that? Obviously the PRT participant. And the trustee performs management and administrative functions that obviously need to be done every year. There's tax returns to be filed. There's accountings that need to be provided, so we can do a PRT annual benefit statement for the PRT participant and so forth. All of that's important. Post-retirement administration, including annually getting together, making sure that things are still moving smoothly, that distributions, when it's time, will be made. All those things, post-retirement administration is important to make sure money's going out to the client when it's supposed to. They hit retirement age, it's time to collect their exempt retirement benefits. Yeah, and the trustee collaborates with PRT team members and assists in the annual administration. Duties and powers of a PRT trustee, one of its most important, defending the trust. We like battle-tested, battle-hardened trustees that don't shy away when it's time to step up and enforce the good work that we've created. Needed to enforce the asset exemption protection under the statute. And what they also do, they have to ensure proper analysis, cash flow management, administrative decisions are being made in furtherance of the objectives of the plan and to mitigate risk. All of these things are traditional functions of a PRT trustee. Active management of the assets, acts in all matters concerning risk management towards preserving the PRT principle. Right? They have a duty to defend. I think that's no mystery. And that's what I would call, I'd say, the probably most important duty, which means the PRT trustee must take all reasonable action to protect and preserve the rights of the trust, enforce the claims of the trust, and defend against legal actions that could harm the trust. And the PRT trustee also has broad powers to do any action on behalf of the PRT which, quote, maximizes, strengthens, enhances, or increases the protection of the participant under the exemptions permitted by the California statute and other laws. Now, what are the trustee limitations on powers? Again, if there's a Nestor, I should say, investment advisor, then the PRT trustee is not going to act with respect to investments. That's the exclusive purview of the independent financial advisor. And there can be a special co-trustee required for transactions involving digital assets. This is just an added level of security, but there's now in the advent of some new platforms, multi-sig and so forth, it's making it simpler, easier to secure the crypto assets for PRT participants through those platforms as opposed to a special co-trustee, and it's a little quicker. We're evolving, just like everybody else is evolving during this very unique time in our financial environment. Things are changing. I think we're moving more to digital as opposed to analog, which at least my generation is solely used to. And Nestor, this is our investment advisor. It's optional, but recommended. It does separate the investment decisions from the other responsibilities of the PRT trustee. Also allows for more specialized investments, trust property, clients that like to invest in real estate. It's always been my thought that it's better to have your exempt balance sheet go and invest in more exempt assets that can be supported in your matrix as opposed to growing your exposed balance sheet. The investment advisor will monitor investment performance, making sure benchmarks are being reached that have been set as goals to realize retirement benefits. Its primary function is to ensure investment and asset performance and to effectuate the success of the PRT plan, has the power to compel the PRT trustee to invest, is bound by fiduciary duties, usually the RIAs and things are anyway, benefits from the PRT retirement planner, who also can serve as Nestor if there is none. And again, the office of Nestor is optional. The purpose of the Pylortes ultimately is to direct the PRT trustee with respect to certain matters concerning the PRT and to aid the PRT trustee in achieving the goals and objectives of the PRT retirement plan. It's really best suited for an attorney that can communicate between the client and retain and maintain confidential and attorney-client privilege communications. I think that's an important role. I do serve as Pylortes to most, if not all, of the PRTs that we've done. But it does support the participant, the Pylortes, in achieving those goals and objectives of the trust. That's key. It will direct the trustee in matters concerning the trust. I do have the power to amend, alter, or modify, again, to achieve the purposes of the trust. And we have it explicitly written in our documents that we have standing to petition the court if need be. as far as being able to have anything of any importance adjudicated if required. Now, the checks and balances of the Poilortes help to ensure continuity and collaboration of the trustee and the nestor. The Poilortes can override the decisions of the nestor if done in bad faith, in gross negligence, or not furtherance of the goals of the PRT itself, and can settle any controversies or disputes concerning or arising out of the interpretation of any language, where the PRT Poilortes is the exclusive interpreter of the PRT itself. Now, the trustee tracks the plan activity, including contributions, distributions, and transactions, generates financial statements, annual statements, reports all the information to the PRT trustee and participant, subject to the removal and replacement of the Poilortes, confirms the plan will be followed, is being followed, and activity is being documented along the way. That's key. Ensuring annual funding to make sure that certain participants' requirement there to reach retirement goals are realized, and to evaluate the retirement appraisal in light of participants' changed circumstances. Net worth might change, income, they might be making more money. Maybe there's more expenses, there's an illness or a sickness. Any or all of these things could necessitate the need to modify the plan, which can be done. But the trustee is right in the thick of it, making sure that, again, everything is running smoothly. And typically our integration as a collaboration and coordination takes the form of, we have a participant, that's the client, retirement planner, he's preparing the retirement appraisal, right? You have the Poilortes, which is your trust protector, could be me or another attorney. You have your nestor, your administrator, and your trustee, all part of what I consider to be the perfect integrated team for the PRT. Result, in summary, the private retirement plan and private retirement trust are complex and comprehensive devices that, if properly designed and used with all of the appropriate ingredients and with the right team members, can protect a participant's retirement assets by recharacterizing those assets as exempt under 704.115B of the California Code of Civil Procedure. Again, has to be properly designed and used. The continuing collaboration among the team members, making sure everything's running smoothly, the yearly maintenance, making sure, again, everybody's following the rules, doing what they're supposed to, and we're keeping up with the client and where they're at in terms of their lifestyle and need. And we can protect the participants' retirement assets by recharacterizing them as exempt if we've done this correctly. Thank you again for your time, spending a few moments with me to learn more about the PRT. Consider myself as a resource to you. If you'd like to schedule a consultation or 30-minute complimentary PRT primer with our firm administrator, Sarah Bracken, feel free to reach out to her and I'll put something on calendar. And again, thank you for your time and attention.